So our next presentation, we were thinking about Carlie and I as franchise attorneys were thinking about what are the common pitfalls that we see in franchise development. You might call this Law and Order Franchise Edition, right? So we're talking about what are the things that you get tripped up on franchise development that might end up on our desks that are easily avoidable mistakes. Some may be easier than others, as you'll see. So we're going to do this. First, a little bit about who we are. So, as I said, we're one of the leading franchise law firms in the country with over 20 years of experience. We've worked with hundreds of franchisors, franchisees, and private equity firms in their franchising activities from launch to exit. We work with both emerging and leading brands in almost every industry. We're going to do this a little bit different than we might do it in the past. So, Carlie, you want to explain how this is going to work?
Yes. So we are using an interactive polling software. The way you're going to be able to join and answer the questions that we have on the screen and be able to poll and give your answers are through the QR code, or if for some reason that's not working for you, there's a QR code on your desk. You could also go directly to the web browser slido.com and enter that code that will take you to our questions. You'll be able to see a copy of the question on your phone and be able to input your answers. We have several varieties of questions, multiple choice, slide to rank, or just open-ended. And we also just welcome any other feedback, questions, comments as we're going along, not necessarily through the web browser. All right, so our first question, I guess before we get started, is there anyone having significant issues accessing the questions? Okay, great. So to get started, this is a common hypothetical that you might experience in your sales process. So you're halfway through the sales process with a lead who will operate in New Jersey. The lead then identifies a non-operating owner to be added to the ownership list who will have a 10% interest. This additional owner lives in New York State. What do? Your options are disclose the additional lead and proceed with closing. It depends on if you are registered in New York. Close the sale as normal, since this is a silent investor, or do not award the franchise. If you'll click next, it'll show people's responses as they come up. So here in real time, we're seeing your answers. Looks like the common response so far is it depends on if you are registered in New York. Well done. Yes, that's the correct answer. Under the franchise rule through the FTC or through state independent franchise acts, you're required to give every member of the franchise team, the owners, a franchise disclosure document. So because this new person is also going to be an owner and they are living in New York, they need to receive a disclosure document. But they cannot do that until you're properly registered in the state of New York. If you already are registered in New York, you can proceed with that sale. And if not, you need to talk to us and we'll help you get through that process. Something to note, kind of the current state of affairs in franchising is the states in the last year or so who are kind of part of an association of franchise registration states have implemented new filing processes. And I think overall it's become a better system, but we are having some, delays of the state in how fast they're able to process filings as of late. So just as you're talking to us, please note that things might be a little bit more delayed than they have been in the past, but we are optimistic that as they work through some of the kinks, it'll be a really effective system.
Great. So next, the franchisee has signed the franchise agreement and lease, is nearly finished with their build-out, has completed initial training plans to train their staff next week, and has begun marketing for a grand opening in 4 weeks' time. What should the franchisee also have signed besides the franchise agreement? So 175% and moving. a second to stabilize. So the answer of all of the above was what 88% of you chose, 89%, and that would be the right answer, right? So the leash rider would be signed, and this is often a mistake that we see, because you're not going to often have the space identified at the time that you sign a franchise agreement, right? Because you don't want to do that. Going back to Mark's earlier presentation, I don't want to invest my time as a franchisor into helping you find your site before you have signed a franchise agreement with me and have paid the initial franchise fee, because I'm not going to put that much effort into site selection to do that. So we signed the franchise agreement, and somewhere along the way, sometimes clients forget that they've got this other thing called a lease rider in their franchise agreement as an exhibit that should get signed. That lease rider, we'll talk a little bit more detail in the subsequent presentation today, but that's giving you the option but not the obligation to be able to step into that space in the event that the lease or the franchise agreement is terminated. So it's very important to get that signed. The operations manager's confidentiality non-compete, same thing. That operations manager may not have been identified at the time that the franchise agreement was signed. But they're going to be coming to training and receiving your confidential information, so they need to be under the confidentiality agreement as well. And then lastly, the phone number, social media handles, and so forth, again, aren't identified at the time that the franchise agreement is signed. So we need to make sure that those get signed prior to opening.
Can you go back one slide?
Oh, sorry.
Just skip it. One more. Yeah, so here we go. So this is a question about personal guarantees. For those of you who might be a little bit more new to franchising, the personal guarantee is what the owners sign that makes them liable for the obligations of the franchise entity if for some reason the franchise entity is not able to fulfill all of its obligations. So the lead is an LLC with 3 members who want to cap the personal guarantee. They also want to exclude spouses from the guarantee. The members have significant personal net worth and will capitalize the business well. Rank your options for responding to their request. Sneak peek here, there's no right answer. We're just curious about how you would assess this risk. All right, so the options were eliminate the spousal guarantee, reject both of the requests, accept both requests, and cap the guarantee at an amount equal to 1 year of royalties. So for those of you who selected eliminate the spousal guarantee, what's your justification and rationale for doing that? Okay, yeah. I mean, quite simply, the feedback you might be getting from your lead is that the spouses are not a member of the LLC. They're probably not directly involved in the operation of the franchise. They're not an owner. And they might be concerned about that personal responsibility they're taking in with something that their spouse is maybe solely involved with. Our response to that is we definitely acknowledge that concern. The other thing to think about, though, is that in a situation if you have kind of a devious franchisee, they might intentionally shift assets to the spouse as a way to avoid kind of their obligations under the personal guarantee. At some point, you do have to trust people and accept certain risks, but know that that might be a risk, is that the spouse is able to take some of those assets that you would normally be able to claim under the personal guarantee. Yes? Yes, great point. It is state specific. Their property laws and marital property laws will all impact that analysis as well.
But for example, like in North Carolina, where we have tenancy by the entirety state with regards to the personal residence, which often is going to be the primary source of net worth other than the business itself, you have to have a claim against both parties in order to pursue it, right? So if I run over a kid on my way home from tonight and kill them with my car, they can't sue my wife for that unless you count that she negligently entrusted me with an automobile. But other than that, there's no claim against her, so you can't get to the house. So it does depend on the state.
A lot of you also suggested reject both requests. That would probably be the most conservative kind of risk-averse option. You could either accept both requests, and we know people who do that. The fourth option is capping the guarantee at an amount equal to some amount. We put up here 1 year of royalties as an example. That might be somewhat of a negotiation tool. So you're both allowed some sort of certainty about the liability that you could all incur and what you can expect to be able to retrieve from that personal guarantee. Just one last note on the spousal guarantee. Even if the spouse is not going to be an operating owner or a member of the LLC, we strongly encourage you to make sure that they're signing a confidentiality and non-compete agreement with you. If you're having franchise conventions and the spouse is coming along with the owner to participate in that, they're just having conversations about the business at night, or they're maybe stepping in to help with the business on a kind of as needed basis, they might have access to your confidential information and your proprietary trade secrets, and you want to be able to protect those.
Okay, so do you accept this lead? So these are the proposed terms. This is an open-ended question, so you can counter with however you feel or whether you would accept them. So the prospective franchisee has significant access to capital, wants to develop 10 units, has demonstrated business acumen, but his kids and staff will run the individual units. He's requested significant concessions. He doesn't have any personal connection to your brand. So is it all no or no, but we'll do this? So far, we're just channeling Nancy Reagan, just say no. In multiple languages. Okay, so what depends on the concessions and the kid's ability? What are we saying there? Who wrote that? Okay, Jeff.
Well, it's just more not depends on what are these significant concessions in terms of manufacturer and location, concentration, other things. And the kids, I mean, they have decent business background in terms of it all. National.
Right. Absolutely. Those are great points. I mean, you need to think about, as you're dealing with pioneers, Pioneer comes along that appears to be a good opportunity for your brand. You need to think about what concessions that you can live with and what ones you can't. Over time, you're most certainly going to continue to work towards a uniform agreement, and you're going to be probably less disposed to negotiating off of your agreement as you grow. Things I would think about here, I mean, where does brand passion fit in? Is it important that they be a passionate advocate for your brand, or if they're agnostic to the brand? I mean, if or your clients or customers. We were talking with some folks at beginning of the conference about you've got to be able to, if you're selling shoes, you've got to be able to deal with people's stinky feet. They may or may not want to fit them with their stinky feet with shoes. So if that's not your thing, or if you're making bagels, you're at my bagel shop, you've got to be able to get up at 4 o'clock in the morning and get to work and start making the bagels. If that's not your thing, if you're a late sleeper like my 15-year-old, then that is not your career path, is to own a bagel shop or a coffee shop. But ultimately, every client's making those decisions of, is this a significant enough client, a prospective franchisee, that they're willing to make those negotiations. Now, you need to make clear whether it's true or not. Your franchisees are going to believe that they know everything that goes on in your system, right? So if you may have a confidentiality agreement as part of that amendment, but the gossip spreads around the system, or what people perceive. It's sort of like that telephone tree game when we all played when we were kids, right? It may not even be what's true, but it's going to get there on the system. So you've got to think, you've got to weigh, if you're making any negotiated changes, against the fact that, is that going to bring disharmony in the system? Is it going to, what are those changes and how are they going to impact the future growth and development of your system?
All right, this lead wants to negotiate removal of your franchisor rights to be purchased by or to purchase a competitor in her territory. Do you accept this change, yes or no?
Okay, so why is that a bad idea to accept the change? Why did everybody vote no? So if you take this provision out of your agreement, what does it have the practical implications of doing when you get to that time of wanting to exit? Anybody? It means giving that franchisee a veto right on your exit strategy. I'm sorry? Sure. So if I take this provision out, and that right is as almost every franchise agreement or any good franchise agreement is going to provide, is going to say that you're not granting an unlimited license to them worldwide or even in their territory, right? There's certain exceptions and carve-outs, one of which is that we have the right to be purchased by a competing brand. So if you're in the home care space and Brightstar comes and wants to buy you and either keep you independently or rebrand you, then you have that right in the franchise agreement to be able to complete that transaction if that's what your franchisor wants to do. But if you don't have that assignment provision in here, then you would have to go and get their permission to sell, which could be withheld, and then you would be trapped and not be able to ultimately exit as a franchisor. And then in turn, some of your franchise agreements may have, or some may not, the ability to purchase a competitor. But you, instead of being bought, you may want to buy out other competitors under either separate brands or under this, or convert them once you purchase them to the same brand. And so you want to have those rights to be able to grow, because that could be you could find a 50-unit location that, a system that needs to be bought and has good franchisees but could be improved, and you want to fold that into your system and rebrand it. If you don't have the flexibility to do that, then the franchisee is going to point to the agreement and say, and they're going to be right, they're going to say, well, you can't buy them because you granted me the right to operate exclusively in that territory. And so and then the question is, can you reflag them or not? Now, they were competing against that person the day before closing. The difference is that, of course, they're competing under the same brand, which may or may not be competition, right? I mean, franchisees, on the one hand, often view competition as being other franchisees, whereas you are looking at it from a market perspective, and as you can build brand recognition within the market, generally speaking, that's going to float everyone's boat higher versus only having 1 or 2% in the market. So the next question is, what strategies are you using to help franchisees open on time despite market and economic headwinds? So this is just an open question. So. Perfect. So thanks, MJ. So if y'all can write in on your phones what answers you have for this question. So what are the things that you're doing to help franchisees get open on time?
Some of the things we're thinking about as we encounter situations where You signed a franchise agreement with someone in 2020 and now it's 2022 and they're still not open. And you may have had limited communication with them during that time. You're really not sure what's going on. So what are situations, or I guess tactics you're using to try to avoid that situation? Seeing some answers up here, you're going to be on site. So doing some inspections and coaching on site. I mean, with technology too, you might be able to request a video conference with them and say, show me around your build out. How are things looking today? Having good power partners. I think also having contacts with supply relationships that you're requiring these folks to use helps you know where they are in the process, and the supplier can be another source of input on where they might be if they're a little bit avoiding you.
And if they're delayed and they're not going to meet their timeline, because most of your franchise agreements are going to say that they have to open within 9 months or 12 months or some time period. Well, what if they've had a delay, they've been working in good faith, they have a hard time finding real estate or so forth? Do you grant an extension? If so, under what terms do you normally do that? So, because you rather them get opened, right? If they're pursuing it in due course, they're not ghosting you or anything, you'd rather them go ahead and get open. So how many people grant extensions, and then how many people condition? And if so, do you put any conditions on those extensions? So commonly what we might see and as a condition would be that I want to release, right? If I'm going to give you something that I'm not obligated to do under the franchise agreement, then I want a release of any claims that you might have against me. Some franchisors might charge their cost back for giving that extension, right? They may have legal fees or otherwise associated with that. Some may charge a fee, but again, you want to think about, is the fee really worth it or not against keeping that franchisee moving and advancing? So we've got some other items. Right, so getting involved, I mean personally involved, right? And hoping, it seems like that seems to be one of the trends on the comments.
It seems like if you're following Mark's advice and having really great systems, having opportunities to communicate about those systems and check-in points along the way would be really helpful.
Right, and having a policy about it, like we may give a free first extension, right? And then we may want something else on the second extension, but having a procedure, then you're also can rely back on that so that if people aren't, if your attempt to recalibrate them to what they need to be doing to get open isn't working, you can fall back on that procedure and be able to tell them what's going to happen next if it's not happening correctly.
All right, next question. The lead asks about net profit when you have disclosed only gross revenues in item 19. It's accurate to state that your units are cash flow positive within 6 months, but you skip on the specifics of net profit, but comment on the cash flow element. Can you make this statement? The resounding answer is no. Well done. So one of the most sensitive aspects of franchise sales is the question, how much money can I make? The franchise rule requires any sort of financial performance representation, which the definition here is, means any sort of statement or representation that a franchisee, expressly or by implication, can achieve a specific level or range of actual potential sales, income, gross profits, or net profits. So since cash flow is related to those kind of calculations and essentially answers in part, how much money can I make and when, that is a financial performance representation. As such, it needs to be included in your FDD in item 19 in order to be able to talk about it. If it's not in item 19, you are not allowed to discuss it with your leads. So you get this question a lot. What are some alternatives that you might have to being able to try to answer this question without giving this prohibited statement? MJ said, referring this lead to your other franchisees. Ben? Yeah, that's a really, really powerful tool. Is once you have multiple units open, is being able to direct franchisee questions to your existing locations. And then if you're getting the question frequently and it seems to be a problem in your sales process, please come talk to us and we can help you amend the FDD in order to give the information that's going to help you in that process.
Okay, so the next question. You've created a new franchise recruitment website, advertisement for LinkedIn rather, and want to target it to professionals living in Washington, D.C., Richmond, Virginia, Greensboro, North Carolina, Baltimore, Maryland, and Tampa, Florida. Which of the following is not a compliance issue to consider? So ads direct leads to a franchise-specific landing page. Ads will launch in 2 days. Ads contain information from item 19, or you are geotagging the ads to appear in certain markets. So which one is not a compliance issue? So the issue, all right, we'll let, the voting's still moving. Okay, so let's go through. So you've got the franchise-specific landing page. Well, that's permitted, right? So that's not a compliance issue as long as you have the proper legends on your website. And that would be the right answer. The other one's the geotagging, for example. Geotagging, what is our problem there? It's what Mark spoke about earlier, is that Maryland is a franchise, both Maryland and Virginia are franchise registration states, but Maryland specifically regulates franchise advertising. And so if it's targeting, whether it's on the internet or not, if it's targeting those who live in that state, then we would have to register it. That is an exception to the general rule. The general rule for franchise advertising online is that you do not need to submit it to the state, that even California agrees it doesn't control the World Wide Web. But they're not sure. They think they might, but they're not sure. But they have to admit at the end of the day that it is the World Wide Web and it doesn't rise and fall in California. So in that situation, though, we're using social media and targeting people in that state. And the states are saying, aha, when we approved 20 years ago the idea that you can do internet advertising and that we don't need to see it in advance, that was before we had this ability to target somebody that lives in a particular zip code or particular area through geotagging or geofencing. So if you're gonna do that, we need to see that ad in advance, because that goes against the whole idea of what we thought as regulators we were agreeing to.
And just to note on the timing of the ad, in those states where you have to present the advertisement to the examiner before you can use it, there's a time component of that. Maryland, I think, is 7 days. So if you're looking to launch immediately, make sure you give yourself enough lead time to go through the state if you need to.
Right.
All right. Another question about your lead. This person has substantial capital, experience, and market connections, and wants to develop a territory that is 3 times as large as the minimum territory that you're disclosing in the franchise agreement. Rank the risks of doing so as you see them. Again, not a right or wrong answer, just what's your perspective on the risks here? So with the ranking ones, you have to slide them up to the box at the top and put them in order. So for those of you who are entering, what's the reason that we're getting? Oh, here we go. It's changing. Never mind. What are your thoughts on these risks, and why did you rank the number one risk as you did? Seems like the consensus here is a very significant risk is the opportunity of not having other operators in that market. If you're giving a very large territory right up front, you don't know what better operator might have come along in the meantime. Second, who knows what the population might do in a specific area. There's been a lot of kind of migration and shifting in across the United States in the last year since of COVID and remote work opportunities, right? People are in different communities than they were a few years ago. So it's hard to predict the future, and your territory might change now compared to 10 years from now when you would have a fully functioning and vibrant franchise business. There's also a risk the franchisee, particularly in maybe a service-based business where the territory really matters, where they're going to be performing their services, might not develop it as well and might be content with really only using 1.5 times the territory where they've really been given 3 times. And then finally, the lawyer concern in us, it's less of a business reason, is item 19. So if you're having data for units that have really varying territory sizes, that can be a concern when you're later reporting and trying to use that information with your leads. You want to try to compare apples to apples. And if you've got dramatically different territory sizes and you're comparing kiwis to watermelons, it's not going to work as well. And you might not have a substantial or reasonable basis for the numbers that you're showing in your financial performance representations.
So that's a really important point on why you need to have some science, or at least some strategy in how you grant the territories. And you're seeing more and more regulators and plaintiffs' attorneys make that argument, right? And they're making the argument that if you're disclosing to me in item 19 your financial performance representation, a territory that's all of Phoenix, that's millions of people, you're granting me 100,000 and my client 100,000 in their territory, then how was that? Did you have a reasonable basis in those financial performance representation data? So the next question, which of the following is probably not a material change that warrants an amendment to the FDD, franchise disclosure document, and or related state registrations? So the addition of a key franchise salesperson, newly opened franchisees that are reporting individual investment that is 15% higher than what's found in item 7. Upon audit of the financial records, you find inconsistency in the gross revenue that overstates the average by $3,000. Credit card transaction fees through the POS go up by 0.5%, or due to supply chain issues, the franchisor determines that it needs to be the exclusive supplier of some major inventory items. So which of these would you say does not require an amendment where we're going to stop selling franchises, we're going to update the document and redisclose to anybody who is in the pipeline? Okay, give it just a second more. So it would be 47% of you voted that it was the credit card transaction fees, and that would be the correct answer, because those do not appear anywhere in the FTD. Those are paid directly through the vendor in this situation. But the other items where you've got a material change in cost, a change of key personnel, change in the supplier relationships, or we no longer have a reasonable basis in the financial performance representation, all those would need to be amended. So the question was if you add a franchise broker or broker network in the middle of the year. The answer would be that it wouldn't change the FTD, but we have to submit, as you may know, we have to submit sales agent disclosures in certain states, or in the case of Washington, we have to register in New York franchise brokers. So in that situation, it would depend on what state you're in, because those two states register franchise brokers, which ultimately just a preview of coming attractions. I mean, the NASA has made clear that they intend to being the state coordinating council, if you will, to propose a model rule on franchise broker registration. So that most likely will be coming down the pike in the next year or two.
All right, so the next question is, which of the following do you consider essential before a lead signs a franchise agreement? No right answer here. We're curious on your perspectives of what you consider essential. You can select multiple options, I believe. There are justifications for each of these. Seems like a strong common consensus is that you want funding to be identified and approved. That makes sense. You don't want someone to be able to, they might not be able to pay you your initial franchise fee, but then being able to get off the ground running and working within those item 7 estimates is really important. You don't want to have issues with franchise compliance or failure just a few months after they're getting started. And having good funding identified is important to that. I guess kind of in contrast to that, though, depending on the type of financing they're obtaining, the lender might want to see a signed franchise agreement first. So the nuance there might be as you're working with the lender. As the franchisee is working with their lender. We also really recommend that you have a new business entity established for the franchisee, so that can be the signatory on the franchise agreement. The reason for that is just it helps firmly establish that this is a business-to-business relationship. It helps them try to protect some of their operating liability by being a business entity rather than an individual. If there are also other schools of thought that say you should kind of close the sale as soon as you can, and you can always assign the agreement over to an entity later. While that's true, it just might create an extra hassle, and you might forget to do it. Operations managers, if it's one of the owners, you might know that from the beginning, but you probably should know it before they're opening. Some want to see that before the franchise agreement is signed. Same with location, et cetera, new bank account, and the lease signed. I think we agree with some of those rankings that some are not essential and some might be recommended after the franchise agreement is signed.
And plus, I mean, on the business entity, just to add one other point, it most certainly substantiates that this is an independent business-to-business relationship when they're actually signing as an entity in signing the franchise there, right? I mean, we want to put up all the defenses possible to the false assertion that there is a direct employment relationship, and obviously if we're signing with business entities, it would be impossible for me to employ as an employee an entity, right? So that's another reason to do that, besides the fact, as Carlie said, that you've got to weigh against the bureaucracy of getting it signed versus forgetting to ever get it assigned back into the entity later. And I know there's brands out there, large brands, Yum being one of them, that I understand, you routinely sign it as individuals because they don't want to wait for the business entity to get formed and then go back and deal with it later. But if you're going to do that, just make sure you're going back and doing it and cleaning that up later, not just forgetting about it. Because it gets frustrating when you're going to terminate someone and you find out that the entity who's been operating all these years, either it doesn't have a license because that entity is not bound by a franchise agreement, not bound by a non-compete either. So the next one, a lead is converting from an independent location. So this is someone that's already operating and is converting and wants to negotiate the continued use of their former point of sale system to keep data and reduce their initial investment. Do you accept this negotiated change? So they're not going to use your POS system, they're going to use their own computer system. Do you accept it, and if so, on what terms? This is a tough crowd, so why would, as everyone say, they're going to make this franchisee spend money? Why are we doing that? Why is it a bad idea to not have them on the POS system? Or what are the advantages of having them on the POS system? So consistency. You can confirm that your royalties are correct, because I can't dial into their system if they're not on the system that we use for being able to pull information, right? What else? Right, it could impact the customer experience. It could have your loyalty program or other things could be run through the POS system. Your ability to get reporting, the ability for you to know that you've got the data to be able to do your financial performance representation in your FDD. All of that is interdependent on getting the actionable information through the POS system.
Well, you might get data on your products that are being sold and services being sold, and knowing kind of real-time results on the health of your system. And then it's just a question of, if this franchisee is not willing to spend a few $1,000s now to adopt your system, what else might they reject in the future? Right,
which goes to the point that Mark made earlier about awarding the franchise. I mean, we're licensing them the right to use our system versus them buying something. When you're buying something, you're buying a car, you can decide whether or not to use the windshield wipers and so forth. When I license Microsoft Word, I don't get to tell Bill Gates that I really don't like his spell check feature and I'd like him to tweak this here or there, right? I'm licensing Word to use it as it's installed on my machine. So you're getting off on the wrong foot from the start.
All right, open-ended question here. What concerns you about these lead scenarios? You have strong leads in Chico, California, Boise, Idaho, Cheyenne, Wyoming, and Mesa, Scottsdale, and Phoenix, Arizona. For some background context, Boise Metro has grown a lot, while Chico has no prime markets near it for your business. And Cheyenne lead wants a big territory to address the rural population they're dealing with. If you're faced with a situation, what worries you about these leads? Got lots of people typing. Registration states, great point. You might be limited in who you can talk to at this point if you're not registered in California in particular. Demographics and population of your target market, right? To be stereotypical, the kind of sunbird state of Phoenix. of Arizona with all those Arizona potential leads there. Supply issues? Yeah, great point. Does it make sense for you to have a supplier who's delivering just to one location in Cheyenne or one location in Northern California? Some of the other things we've talked about, kind of hinted as well, are, okay, I like these two, that real estate costs are going to be really different from market to market. You might not be able to get open for those numbers that you were talking about in item 7. That might be kind of a compliance risk if they're not able to open timely or with a lot of capital because they underestimated how expensive it was going to be in prime markets. Other things to think about are continuing changes. So you award a Boise territory, let's say it continues to change significantly and grow. All of a sudden they're a lot bigger than you want. Their population in that territory is much larger than you would normally award. Or vice versa, where the growth is not sustained and you anticipated that it would be. Can you have your operations team go out and support these units that are perhaps more remote from others, right? If it's going to take, if it's twice as expensive to visit the Cheyenne location as it is to go visit your Dallas location, are they practically not going to be visited as frequently? And is that going to hurt their performance? Are they going to be more willing to go rogue, for example? You might not be able to have efficient supplier chains, as you guys have mentioned. The questions about market penetration for the Cheyenne territory that wants to be really larger than all the others. And then just all the concerns about what the future will bring. One concern with having territories close together with Scottsdale, Mesa, and Phoenix might be, okay, so we have a lot of three units that could be potentially close together. How do we strategize to place those units in the best way and giving them the right territory size?
So the next question, your primary trademark has not yet been registered with the trademark office. We've given you a set of business opportunity disclosures to use in South Carolina because you don't have a federally registered trademark, so you're not exempt. You now have a lead in South Carolina. When should you give the additional disclosure to the lead? 48 hours before signing, at the first personal face-to-face meeting, at the time signing the franchise agreement, since it's all the same stuff anyway, or along with the FDD. So if you are in a state that you are not exempt from the Business Opportunity Act, then if a good rule of thumb is to do it along with the FTD, because we'll always be okay by doing that, versus trying to remember each state's individual situation. But of course, the goal is not to be having to do business opportunity disclosures at all. So you want to get your trademark registration as soon as possible, because the sooner you get that, then in almost all of these business opportunity states, you will be exempt from having to have a separate disclosure.
Yeah, just for record, the USPTO is taking a really long time to process applications right now, so you're looking at about a year in order to get really substantive action on your application. So unfortunately, it is quite a wait time for that.
They've improved as of late, but they're still very behind. All
right. This is a little bit of a trick question because the answer is all of the above. I'll give it to you. We just wanted to take an opportunity as you're looking ahead. Many of you have a December 31st year end for the things that you can do to help make your FTD renewal cycle and process a lot smoother as you're working with us and other suppliers. So the first is obtain your franchisee financial results early. Hopefully that's automated through your POS system or some other reporting system. But the sooner you get that data, the better, because then you know what kind of Item 19 representations you might want to be able to make. Maybe you want to add a new type of data that you haven't done before. And that's best done if you have the data early. Second, once you enter your second year of franchising, you're absolutely going to need an audit. Auditors can be very busy, particularly around the beginning of the year with the tax cycle. So contact the auditor prior to the close of the fiscal year, perhaps now or even earlier, to get them synced with your schedule and your anticipation of when you need the FDD to be released and the audit to be done. Similarly, communicating the renewal deadlines will be helpful, and do your work as soon as you can to make the auditor's job simpler, and having your information ready as soon as you can after the close of the fiscal year end. I know we have some accounting service providers in the audience. Do you want to make any comments on what would make your job easier for that? Okay. As you're working with us and talking with us, please keep your notes for the things that you're encountering during the year, questions you're getting from your leads and from your franchisees, issues you're encountering with compliance or operational challenges, because then we can work to incorporate those in the FDD. If you have big changes, if you can give us those at the beginning so we have time to think through it and make sure you have a thorough product. If you have the option to file towards the beginning of the renewal cycle or the end, and some of this is subject to your very specific state registration dates that can sometimes become fixed in time. But where you have the options, it is in your best interest to file at the beginning of the renewal cycle. So for example, if you're able to file in late February, early March, and it's not going to be harmful to do so for you, that's going to put your application in front of the examiners a lot sooner when they have a lot less on their plate compared to if you're filing April 30th, where there's hundreds and hundreds of applications ahead of yours. Then managing your sales pipeline well, we'll talk a little bit about that on the next slide. So we can go there. So when the FDD will expire, okay, so it is valid through April 30th 120 days after the close of your fiscal year end. So for those with the December 31st year end, that is April 30th. As you're thinking about your sales in the months that are from December to April, you need to be strategic about how you're handling those incoming leads. For those who are able to close and ready to close before the FDD expires and before you have to file your updated state registrations, it might be instrumental if you can to kind of fast pedal those or give those leads the attention they need to be able to close. So you're wrapping that up without having the process that lingers on during that renewal period where it can be a little bit more complicated. Communicate with your sales team and your broker networks so that everyone's on the same page of how you're going to handle the leads that come in from December to March, for example. For sales that do not close prior to the date that the old FDD expires, you need to consider the following. If you are not in any sort of franchise registration state, arguably you have some flexibility, a little bit more flexibility with when you close the sale and whether you can use the old FDD or not. But many, and talk to us about those circumstances, because in many circumstances the answer still might be that it's best to give that prospect a new FDD and begin the disclosure period again, those 14 days. And that's certainly the answer in states where you have to register. You need to pause your sales discussions during the time that your application is pending, and then once it's approved, you're able to pick up those sales discussions with the new FDD.
So now we're going to talk a little bit about the franchise compliance questionnaire. Mark alluded to this earlier in his discussion, right? So many franchisors and franchise council over the years have used these kind of questionnaires as part of the closing process on a franchise offering. It was important to the franchisor council would argue that it was important to them to be able to know, for example, if there was something bad that happened in the franchise disclosure process, in the franchise sales process, so that we have a chance to rectify it before we sign a binding agreement and expose the franchisor to liability that wouldn't be necessary to expose the franchisor to if we knew about it in advance. The state regulators and franchisee advocates, some would argue that these questionnaires were used as de facto waivers, right? They would say that, well, the purpose you're using, you're having me sign this now. My client may not even understand what they signed, and then later, when in their mind the quote truth comes out, otherwise a different story is what the Franchisor Council would say, that has developed over the passage of time. Then we're now in a situation of debating whether that questionnaire was the truth, or what they're saying now was the truth, right? The proverbial, are you lying then or lying now? So you have these registration states that have come together through NASA and said, okay, we may, and I would say use the word may, and I'll explain in just a minute. Depending on our state, this may violate our law. And so if we adopt this statement of purpose, then you will not be able to use questionnaires in the conventional sense in our state, whether they're oral and recorded, right? Whether they're recorded in writing or through some other vehicle. So you couldn't record a Zoom call, for example, and then use certain questions. So they are prohibiting, 13 or so different questions that are probably fairly typical on these questionnaires. So the question that each franchisor is going to have to answer for itself starting in January, because this begins in January 1st, the questions you're going to have to answer for yourself are, am I going to have 2 FDDs? I think that's question number 1. Because there's still at least 35 other states where I can use these questionnaires. And the reason I say at least, because the fact that NASA pushed this SOP out by their own admission, each state has its own right whether or not it's going to adopt it. I mean, we know that California, Washington, and Maryland are going to adopt it. Those are the only 3 as of right now that we know are going to adopt it. So the question that each franchisor is going to have is, do I feel that having this questionnaire available so I can make sure I'm entering into transactions with people that believe I didn't break the law at the time that I signed the franchise agreement, is important enough to have 2 FDDs. Alternatively, the other option, we met last week 2 weeks ago with the Teresa Leitz, who leads the California regulator effort and is also the chair of NASA. She said, hey, look, you can still do a phone and you can do information finding. I don't have a problem with you doing information finding. So I can have somebody do a pre-closing call with the franchisee and ask them questions over the phone. I can't record it, but I can go write a memo to file, says that I ask these questions that I ask every other time to people, and they all answered them in the affirmative, that there was no reason not to move forward. And then you've got documented evidence of what you were told by the franchisee. So you can document that yourself. You just can't have them sign it, and you can't record them saying it. And then so that's really the gist of the rule. So it doesn't go as far as a lot of people think it does, but it is something to think about as you go into this new season. And like I said, this is the one from Remax, for example, and probably looks similar to a lot of what you have. I mean, these are pretty ubiquitous out there.
All right, so our last major topic is just be smart in your writing. So as part of a regulated business model, there is going to be conflict between you and your franchisees at some point. Even if you do everything right, even if you are very supportive, very successful, at some point inevitably there's going to be conflict. When that conflict happens, your written communications might be the only real record of the true story of what has happened during your relationship with your franchisee. The communications around the time of sale are very important. There's often questions about fraud and what were you representing to your franchisees at the time of sale that was different than what was in the FDD. So as attorneys, we have an obligation to keep your information as our clients confidential. And something that springs from that is called the attorney-client privilege. That means that if there's a legal dispute, that certain information is not discoverable or cannot be used as evidence in a dispute. Basically, the other side can't use it against you. The goal of that is that when you're talking with your attorney, it should be private and confidential. You should be able to trust, be able to give all the facts to the attorney without questions that's going to be used against you. However, to establish privilege and maintain it, there's a lot of different factors. Some of the important factors are, was the information confidential at the time that it was given? And then did the client then go and waive the privilege by sharing it with somebody else? So to preserve your attorney-client privilege, we recommend the following. Be very careful with who is participating in discussions with the attorney and who is receiving information that the attorney is providing. So your third parties that are involved in the relationships you're having with your franchisees, like brokers or suppliers or the franchisee themselves or their attorney, all these people sometimes can get looped in on communications, and email is a really bad culprit for that. Do not copy or forward information that you want to be confidential and protected, that's a communication with your attorney, to your leads, to your franchisees, or to third parties. Second, keep communications and forwarding with the internal decision makers who need to know. So be strategic about who you're informing about these important decisions, where there's a compliance question, where you're weighing risks, where it's talking about the franchise relationship and where it's going and it might be terminated, or if there were questions about issues in the sales process. Keep all of that between the people who really need to know. So to sum it up again, don't copy or forward emails that you have with your attorney to your leads, to your franchisees, or to third parties, and limit communications you're having on important matters with the decision makers at your franchisor and the attorney. Second, remember that every written communication you have has two audiences, the intended recipient and a court. There should be some sort of like a Miranda warning that anything you write can and will be used against you by a franchisee's plaintiff's attorney. Because what you leave in written records of the communication is all they have to kind of spin and twist to tell their story. That would be our perspective as a primarily franchisor attorney. With that, I mean, recall that if there's messy decision making that's involved, it might be best to take that to the phone. So when in doubt, pick up the phone. I heard recently someone's rule of thumb was if a question can't be answered in 3 text messages, you need to pick up the phone. You know, so if I'm communicating with my friends and we're trying to decide where to go for dinner, if we can't decide in 3 text messages where we're going, someone needs to call someone and figure it out. In really important compliance questions or questions about, you know, the direction of the brand or whether you're going to accept a franchisee or issues about operations, those are much more complicated than where to go for dinner. Make sure that you're having phone call conversations about that, where you can work out the messages or your decisions in a kind of more free way without the endless back and forth. With those phone calls, though, if you're concerned about there being a misunderstanding about what the conclusion was or the main points of the call or what the final decision was, it's totally fine to send an email summarizing the results of that call and make sure everyone's on the same page. But it might be tactful to leave that off of email, the in-between process. And then train your team on these principles, because what they say is going to be reflected on you as the owner of the business. This is not intuitive in our communications today. It's all very informal. It's very fast. Lots of people don't pause to think before they're writing stuff down. That's not an intuitive skill anymore. So train your team on this to try to protect yourself and keep information that you want kind of safe and protected that way as long as you can.
All right. Thank you, Carlie. So Jane's sales broker admits in a text message that the broker gave additional financial performance representations to a lead that they just signed. Jane unleashes a tirade over text to the broker and then sends an email seeking advice to her attorneys, copying the broker. So what went wrong? Responding via text to the broker, copying the broker on the email, and seeking the attorney's advice. Gotta watch those lawyers. So what do we have here? So copying the broker, as Carlie noted, I mean, that broker is not an executive of the franchisor. They're not part of the decision-making of the franchisor. So copying the broker would be the first one of the mistakes. And then responding to the text, depending on what was said, that could be devastating, right? If it ends up turning to an endorsement or otherwise of what the broker had done, right? So slowing down, calling the broker to obtain the information, calling the attorney, making rational next steps before just blasting the broker would be the best thing to do. And also we need the broker to tell us everything that's going on. So if you're blasting them right out of the chute, then you may not get the full story and you're gonna find it out later in court. And so we need to be able to have time to do an investigation. Sure. Okay, well, this is where that questionnaire would be helpful in advance, right? Because hopefully then they would have initialed, yes, I received something other than what was in the FTD, and then we could have had them sign what we call an affidavit of non-reliance to say, hey, I was told this by the broker, that was wrong, I understand that's not accurate information, and I still want to close anyway. Well, that defeats a fraud in the inducement claim, generally speaking, right? Because there's no inducement, right? They didn't rely on it. There was no reliance, which is one of the elements of proving a fraud in the inducement, where basically a fraud in the inducement claim, for those who don't know, would be, hey, I told you something, and because I told you this, you did something else, right? Well, here they disclaimed that they did it as a result of that. There was no reliance on the statement, and therefore there's no fraud in the inducement. What becomes trickier here, once they've already signed, you would perhaps need to give them a rescission right, would probably be the way to resolve it. If they still want to move forward, give them the opportunity to get their money back, and then they can decide whether they want to stay in or not. By doing that, well, that's not a surefire remedy in this situation where they haven't already built out the franchise. What damage do they have at that point if they've been told this statement was not correct, they were given a chance to get their money back, and they chose to go forward anyway? It would be more difficult for them to claim that they were damaged as a result of the statement.
All right, next question. What's the consequence of this situation? Jane's operations team emails her with info that the franchisee failed the second inspection. Jane responds they should consider a default notice. The operations team member responds in an email, yeah, that would be good because he's a real pain and should have been kicked out before. The result of this is that if it leads to termination, if that's what ends up happening because the franchisee cannot cure the default or has another issue, and that termination then is disputed, this communication is likely to come out in discovery. This person is correct. There's a paper trail. And all of a sudden, it looks like the reason that this franchisee was terminated was not because they had compliance issues, as noted with the second inspection being failed, but because of a personal bias or issue with this operations team member and the franchisee. So the moral of the story here is when you're commenting about your franchisees and perhaps expressing negative things or frustrations, that might be best done over phone so that it's not part of the record of what you think and feel and how your relationship with the franchisee is proceeding. I mean, not, you might, yeah, or maybe some retraining on your operations team member, but exactly, right? So there can be significant consequences for this little comment that someone made in an offhand way. I'm going to say this is going to happen though, right? Because people are going to make comments. And you just try to minimize it as you can and try to build your evidence in other ways when there's an issue of termination.
Everything's a learning opportunity, right? So Elite's attorney has provided an amendment to the franchise agreement for consideration. Jane sends the amendment to your attorneys who provide comments on it. Jane reviews and forwards the draft directly to the lead as received from the council. So what's wrong with that? So some of the things would be that obviously this transmission, if they're just forwarding the email from the lawyer or the lawyer's comments that were designed not to be forwarded to the other side, then that could potentially waive privilege. You could lose insider knowledge about your negotiation tactic. It may be harmless, but if there's a dispute about the document in the draft might become discoverable, and it could run the risk of the whole issue, privilege having been waived about the whole issue, not just the draft itself, right? But the whole recruitment of that franchisee. And so that's why this is important. But again, it's not that big a deal. If I send you a draft, I'm probably writing my comments in the body of the email and marking up something that's ready for them to be sent to the other side. So why can't you just delete the bottom before you forward it on, right? Because we intend for the markup to go to the other side.
All right, last question. You made it. Jane gets an email from a franchisee letting Jane know that he wants to shut down his unit in 7 days because he can't meet payroll. The email copies the operations team and a neighboring franchisee who would probably service his clients after the closure. Rank Jane's options for next steps. 1, call the attorneys, Manning, Fulton, Skinner. 2, call the franchisee directly to request a better wind down option rather than just shutting down suddenly. 3, texting the neighboring franchisee to reassure her that you will not permit the shutdown. Respond by email and acknowledge that the franchisor knows the franchisee has been struggling in the market with the new sales promotion, or email the operations team member asking for a list of all the dirt on the franchisee's compliance. So no right answer here. Just what are your options and how would you proceed? I guess I would say some are worse than others, though. So working backwards from the bottom, it's not going to be strategic to email their operations team member asking for all the dirt on the franchisee's compliance, right? That's very similar to the situation we just discussed about making sure that your communications about franchisees, if they were going to be discoverable and read by the franchisee, are something you would want them to read. Texting the neighboring franchisee to reassure her that if the other franchisee is not going to shut down, it's probably not the best position because you haven't reacted and reasoning through all the scenarios yet. You probably don't want to involve that next franchisee until you've confirmed what your plan moving forward is going to be. You don't want to have contradictory information, and also I think texting can be a little bit dangerous. Responding by email and acknowledging the franchisee's struggles, the risk of doing that is that somehow you've admitted some sort of culpability in the franchisee's failure, and you don't want to do that. I mean, responding with empathy and concern is probably a good option, but don't say that you guys did something wrong. We always recommend calling us, but also I think it's important to get on the phone quickly with the franchisee and figure out what's going on and what options the franchisee might have to working this out in a way that's not going to hurt your system.
Well, thank you for your participation today, and hopefully you took away some nuggets that will help avoid some pain points in the future for you and your brand.